attorneys will always say, hey, any questions after an officer asks pertaining to the nice circus, like Frank,
Nice job, Frank.
Yeah, Frank is a follower of our stuff here. So question officer asks pertaining to the crime after Miranda is invoked cannot be used in court. They may still ask the questions, and although the statements cannot be used in court, can still be used to impeach the person. Robert, just real quick, what court or what state are you in? So while Robert's writing that, you get what's going on here, right?
Mm-hmm. Yes,
Hey, I'm the suspect. Hey, I don't want to talk to you. I read Miranda. You have the right to my son. Hey, I want to. I want an attorney, and the cop still speaks to me or still asks me incriminating questions. What do you think about that?
That's a problem. That's a
well. Is it a constitutional violation?
Well, the Supreme Court adopted under Miranda. It wasn't written into the fourth in there, but Fifth Amendment right there, right? You have the right against self-incrimination, and then we have those protections that were invoked where when you ask for, especially a lawyer, questioning ceases. Incriminating question ceases.
All right.
For how long?
Well, 14 days, but 14 days post Miranda custody. So let me tell you what the answer is. The answer is that as it stands today, I don't have July 13, 2023, you could continue to ask him questions. And the reason why is because, Rick, do me a favor. What's that latest, that Fifth Amendment Miranda case from the U.S. Supreme Court? It starts with a T. Okay. It's TEM something. So Rick, just U.S. Supreme Court, Fifth Amendment Miranda, civil rights violation. Just put that in tell me what the case is.
Is that how your brother types?
If
he does it, that is going to be a while.
I mean, he is a pecker. So here's the deal, okay?
Because I'm kind of curious.
Yes, here's the deal. Now, first of all, we don't teach this.
Okay,
and that's why I like what you're doing. We don't teach this, but push comes to shove. Because Miranda is not a constitutional requirement, it is a prophylactic. It's a condom. And it's there to protect a person's, Fifth Amendment rights, and they do this kind of like this gatekeeper stuff. So here's the thing. Because the U.S. Supreme Court recently in 2022, I think last year, has said that Miranda violations do not constitute a civil rights violation, which clearly this is a Miranda violation. You would agree with that?
Yes.
Because Miranda violations do not constitute a constitutional violation, we don't have any violation as long as we do not introduce their testimony in the case in chief. So, as long as that prosecutor does not introduce those, no, that's not it, Rick. That's not it.
So is this
it's a 2023 case, Rick. It's a 2023 case.
Is this a court decided off the record?
What do you mean court decided off the record?
Like the court almost saying off the record information from a person, like, okay, hey, we're not going to use this in court. You can't say you can't use it.
Well, the problem, okay, that's what it is right there. Thanks, Willie. I knew it started with a T. I got that part right.
There you go.
So it's Villa to Tico. So Vega versus Tico. So thanks, Willie. So what the Supreme Court is saying, hey, look, you're violating Miranda, but that's a prophylactic. It's a gatekeeper type thing. It's not like the off the record, because off the record kind of tells them, you're giving them kind of like an agreement. Hey, whatever you tell me won't come into court. Here, you're saying that basically, I mean, you're not saying anything, but you're implying that it won't come in their case in chief. And that's the issue. So can you use it from Miranda? Yes. And here's the other thing you can use it for: evidence.
Okay.
So imagine that a guy says, let's say he has a gun somewhere in the house, right? Or in the car. And the cop says, hey, look, the guy says, you read a Miranda, you have the right to remain silent. The guy says, I want a lawyer. Okay. And the cop says, I respect it. I got it. I don't respect it. He's not going to respect it. Hey, I hear you, but where'd you put that gun? Now, not a public safety concern.
Right, not an exception.
No,
right,
not an exception. Yeah. Not the gun.
It's in the house.
It's in the house, or it's in the car. And let's say it's in the car, and the suspect says it's under the seat. Now the guy's a prohibited person, and the cop uses probable cause because he just told him it's under the seat, and goes in there and grabs the gun.
Verbal PC, right?
That's verbal PC. I got some good news and some bad news. The good news is that that gun, based on these facts that I've given you, is coming in this trial. Because Miranda violations do not equal evidence suppression unless the person has been coerced.
Correct.
He has not been coerced there. He's not had a gun to his head or the phone book out, or threatening his kids with CPS. That if you don't speak, I'm gonna send your kids to CPS. And
There might be some young officers out here that don't know what a phone book is.
Oh, the phone book is the whole, like, you beat somebody with a phone book. Oh, they don't even know what a phone book is. But the whole idea is that you beat this guy with a 600 page book, and it doesn't leave marks, but it hurts him.
Remember, we talked about how old we are earlier.
Yeah, correct. And now that you have this this prison thing that you got going on there, it looks good. So the point is that I don't teach this because the Ninth Circuit has stated that if they are seeing evidence where cops are purposely violating people's rights, they may find that it's a violation of Miranda. So it's one thing to do it on accident. It's one thing to do it inadvertently. It's another thing to do it on purpose. We don't teach it because it's unprofessional, but I want to let you know, as it stands today, it can come in.